Here, here, I'm gonna give this back to him. Tragic waste. Brian David Henry is called next, 25 CR 1327 and 1328. The defendant is charged in each case with the first degree felonies of continuous sexual abuse of a child under 14. If convicted in each of these enhanced first degree felonies, we're looking at no less than 25.
Yes, sir.
No less than 25 years in prison up to life imprisonment. I don't believe there's a fine on these. So it's 25 to 99 years confinement or life imprisonment. Also, the parole on this is day for day, isn't it?
That's correct.
So the minimum sentence is 25 years. And if sentenced to the minimum, the defendant would have to serve 25 calendar years before he would be released. So look at the thing here. These are not two separate events with the same child. These are two separate children younger than 14 years of age alleged to have been victimized, correct?
That's correct, Your Honor.
All right. Is there any other enhancements there?
I don't think so, no.
It's
I'm aware, Your Honor.
no.
I haven't seen any
1327
prior.
looks like it alleges.
That's actually the count of the number of conduct or the continuous.
19 separate methods of committing the crime alleged in one of them. And 1327. That's what it alleges. It's what, and then the other ones. 8 allegations of criminality in 1328 of that child. Now, the defendant lived in Newton County, but these all occurred here in allegedly in Jefferson County, Texas, correct?
Yes, sir.
The age of the children, I don't see how.
16, and the other one is over the age of 18.
Couldn't have been at the time.
Not at the time.
No, I'm talking about the time of the event.
Well, that's
Do we,
Let's see.
5 for one,
6,
and 11 or 12 for
it's
the other.
allegedly December of 2015 and 1328 and on or about December in 2016. So what would the ages be?
Years for one and 11 or 12 for the second child,
Okay.
which is the one alleging 8 separate offenses.
The female,
Or
it's the female.
that's correct.
Okay. Today, what are we doing?
So we have a bond hearing or a bond reduction hearing scheduled for today.
Okay, stand by.
Certainly.
Public safety.
Nice to do it. Safety report. A safety report. I don't think he has one.
When there's a bond here, I have to have a public safety report now, as law requires, so the court knows if there's any other criminal history, among other things, that the public safety report reports. But while we're waiting, go ahead.
Yes, sir. So I have filed a motion to reduce
The bonds are
the
what
bond,
right now?
500,000 each.
In each,
Yes, sir. In my motion, I have requested that the bond each be reduced to $25,000. Or that he be released on his own personal recognizance. And
Let's see that. Let me move back.
Keep going. I'm with you.
And Your Honor, if the court so requires, for the defendant to be released, we're asking that he be ordered to wear a GPS or global positioning system monitor tracking device. He is from Newton County. He lives and has resided in Newton County for several years, as well as Jefferson County. He has ties to the community in that he's always resided in the area. He's was currently or was employed at the time of his arrest. And there's been no evidence that he would abscond from justice or would not appear. And these are allegations, Your Honor. They have not been proven. There are a lot of factors at play here in this case that the court is unaware of.
I see.
So. Your Honor, Mr. Henry also suffers from a physical disability. As you can see, he's confined to a wheelchair because prior to his incarceration, he has to wear a leg brace.
What?
Well, he can't walk without his leg brace.
And so what's the point? I mean, everybody has a disability of some sort. We're all
Using
imperfect.
that as an excuse or a reason for him to be released, but clearly he has that would also hinder him from absconding if, in addition to him wearing a global tracking device.
Although the grand jury has in its allegations, it didn't hinder him from allegedly committing two of the most serious types of crimes that the state penal code has printed and determined or punishable.
John. Jones.
I understand, Your Honor. Still,
These his children,
I'm sorry.
these here.
One is the biological daughter and the other is a stepdaughter.
Your, may I speak?
Just a second. You've got a chance to speak here in
Yeah.
a minute. Anything else that you want to add?
Your Honor, Mr. Henry's wife is present as well in the courtroom, Jessica Morales. And she will also ensure that he makes it to court. She understands as well as Mr. Henry that these are very serious allegations. It's every intention of his to appear for every scheduled court date. And I believe that due to the amount of the bonds, it's unreasonably
I've seen a
high.
lot higher.
I understand the court's position on that, but and a man of his position, he's unable to make bond at those amounts. And I believe that he's entitled to a reasonable bond.
I think that's true based upon the provisions that the laws provide for and not everybody gets a bond that they're able to afford.
And Mr. Henry doesn't have a record. He was, prior to his arrest, gainfully employed, productive citizen. And again, these are allegations and I don't want to argue the case, but everybody is innocent until proven guilty.
Unless proven guilty.
Unless Sorry. And we just believe that he should be given an opportunity to make bail so he can continue to provide for his family and go back to work.
Stay.
Judge, this is not an unusual bond for these type of offenses we've had in this court. And looking at the ages of the children at the times, the amount of actual contact he had that's alleged in our indictment.
What are the ages of the children at the time it is alleged that he sexually abused them?
But she stated, Judge, that they were, one was 11 or 12 and 10 or 11. The other one was about 5 or 6, depending on the age group, because there were several years involved.
In each of these cases, it's alleged there were multiple acts.
Yes, sir. And
What quantitatively does the state understand how many are we talking about?
well, each one has its, as the ones we've alleged in the indictment. So we've got the 8 of the one and I think over 12 to 15 of the other. So every one of those is an incident. So we think the bond is fair. We think for not only for the safety of the victim, safety of the public, but this man may not run normally, but this is 25 to life and he's facing a lot of time without parole. And so we would think just to ensure that there's no contact, no safety issues with the victims, since they were family members, that we would ask for the bond to stay at 500,000 on each one.
Anything else you wanted to add?
I think that Mr. Henry would like to say something.
You want to say something, sir?
I would, Your Honor.
Hold on, raise your right hand. As best you can. Do you solemnly swear or affirm any statements that you are about to make shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Lower your hand. Go ahead.
If you will allow me to make bond, I'm not gonna run. I mean, if they would have called me, I'd have brought myself to them and turned myself in. I don't run.
The
I mean, I'm innocent. I did not do this.
Well, you can imagine everybody says that who's in here,
Okay, Your Honor.
and you have a presumption of innocence
Yeah,
under the law. The grand jury, though, has deemed probable cause exists otherwise, and that's where we move from.
Okay,
The law provides that the bonds that are set are not necessarily a hearing based upon a hearing of witnesses, but based upon information that the court has. I have probable cause affidavits in each of these cases and other information that the court has referred to. The legislature that enacted this law set forth this confinement, this punishment for each of these offenses. It is only superseded by capital murder convictions. That's the only more serious punishment range in the state of Texas for such a crime. So it has its level of seriousness, which is most high, that the legislative branch set the laws for. So, and the court bases bond hearings on a couple of things, not the least of which are the information that the circumstances of the crime alleged and criminal histories. Those are the two major components. Here, I don't see a criminal history as a factor. Nonetheless, the seriousness of these allegations, as found, probably occurred based upon probable cause of the grand jury decision, or as we said, such a serious crime. Only more serious is capital murder, which is death penalty. And what we're also speaking about is that the victims are not adults; these are children. What is the price of the loss of the innocence of a child? What is the price? What is the value? Anybody want to say there's something more important on this planet than that? No. That's what we're talking about. these circumstances. So. Uh, anything else you want to add? You wanted to say something?
I mean, I'll comply with whatever conditions the court sets for me. I mean, GPS tracker, whatever y'all want me to do.
How does that prevent you from harming another child if
I
this
haven't-
occurred?
I did.
How would this prevent you from harming a child if you wanted to? How does the global positioning track device prevent that? It just shows where you
I
are.
don't drive.
It doesn't prevent you from committing an act.
Chemically castrate me. It doesn't matter. I didn't do it.
Okay, well, that's why we're going to have a jury trial on this, is what we want, right? On a jury
Yes.
trial. Let's get this moved. We'll get this moved quick enough.
Yes, sir.
Your request for a bond relief is well presented. It's denied. The court feels the circumstances of the offense as the probable cause affidavit show. Put this court in such a position. How can I guarantee a child safety under these circumstances? And yes, you're presumed innocent. I wrote the leading article on that. I'm in the state of Texas, so I believe in that. But the probable cause, but the law states circumstances of the crime through information that the court has or is part of the equation in determining bond. And I'm going to say again, only capital murder this court finds is more serious than the allegations of two separate indictments alleging two different victims in these cases. So that compounds the problem. There's not one. I'm looking at the public safety report here that the court is required to review. And this shows that in 1999, you were charged with illegal possession of marijuana and burglary of a habitation. What happened in those?
It was dismissed, so.
I don't know what happened. I just now heard about that.
You
When
don't.
they arrested me during my arrest.
This is under your name, under your data. It's like, it says
No, the specifics about,
supervisory caution. It says
But it would-
supervisory caution, whatever that is.
I would have to do like.
there was no
level.
conviction, whatever it was disposed of.
And that's all the court is really on criminal history. If you don't have a conviction, there's not. Now, but then people could be placed on deferred or unadjudicated probation and admitted it.
It doesn't.
But that's
say
not
that
what I'm saying.
the Case or on.
Okay.
If, sir, somehow you were able to provide bonds in these cases, the magistrate who set these bonds originally at $500,000, I can't read the signature.
We'll show up.
But he or she provided that there will be no contact at any time of the victims. You must have a GPS device and remain in Jefferson, Orange, and or Newton counties if you were able to post a bond. So those would be required if
Sir.
you were able to post a bond in these cases.
Why? No, just.
Anything else?
No, sir.
All right. Again, the probable cause affidavits are part of this hearing in each of these cases, plus the public safety reports. All right. And this will be set with how you want to
Yeah.
represent it. And when can the state be ready on this? We're going to fast track it.
Yes, sir. Since we got holidays coming up,
I know it has to
we
be.
could do it right after the holidays because these girls.
Can we set it for late January?
Yes, sir.
All right, it'll be set for January. Thank you.
Thank you, sir.